arrived to evaluate the readiness for implementation of the rule relating to the drought volume exemption. As everyone knows, Arizona, along with others in the basin, has been confronting uncomfortable uncertainties regarding the Colorado River for a considerable while. These uncertainties have been mounting through the year, as has been reflected in the exchange of letters in the spring, the protection volume discussions during the summer and early fall, and presently the process for the supplemental environmental impact statement. As Director Bushotsky has indicated, we are encountering uncertainty on top of uncertainties. As I have frequently said in presentations and panels, existing challenges have been intensifying, and we are increasingly working through novel challenges, new problems to solve. Concerning this problem to solve, the desirability of additional guidance for the drought volume exemption, we assembled a broad team involving, of course, the Director, Tom Bushotsky, Nicole Clovis, our Chief Counsel, and other ADWR attorneys, the Arizona Water Bank team, and managers and staff from the Recharge and Assured and Adequate Water Supply sections, Colorado River Management, statewide planning, and the active management area section. It was a good and thoughtful collaborative effort. We now seek your input to further inform our choices as we complete work on this substantive policy statement on the drought volume exemption. Again, thank you for your participation. Cool.
Yes, thank you for accommodating us. We know that this is a very short turnaround time, both in terms of the meeting notice and the review of the draft policy statement, but we will walk through that policy statement today. We would like to make sure that we get a policy statement out before the end of the year in order to provide guidance to water users with respect to the drought volume exemption. We can go to the next slide. So our agenda today, we've been through the welcome. We will go through a background of the drought volume exemption and what we're even talking about, a policy statement overview, and then we will have time for public comments. And we also anticipate that you may have questions today, and we are happy to answer those questions. And then we'll talk through the next steps in the process. The drought volume exemption is based on the assured water supply rules and creates an exemption from the requirement in those rules that groundwater must be replenished for assured water supply purposes. More specifically, we have the rule provisions. And so rule language I know is always really fun to read, but be patient with us. So drought volume means 80% of the volume of the surface water supply determined by the director under our physical availability rule to be physically available on an annual basis to a certificate holder or a designated provider. So that term is important to understand when we get into the exemption language. So Arizona Administrative Code R12-15-722G1 provides that specific volumes of groundwater are consistent with the management goal upon application. And the first volume of groundwater that it defines is under G1, if the director determines that a surface water supply is physically available under R12-15-716, and the volume of the supply actually available during a calendar year is equal to or less than the drought volume for the supply, the volume of groundwater other than the groundwater that is accounted for under subsection A, C, or E, withdrawn within the AMA that, when combined with the available surface water supply, is equal to or less than the drought volume. So now you all know exactly what a drought volume exemption is. Next slide. We've tried to translate this from legalese. Lawyers aren't always as good at translating, but I've done my best here. Based on the volume of a surface water supply that is physically available in the assured water supply determination, and I'll refer to that throughout this presentation, and it's also referenced throughout the policy statement as the determination volume. If less than 80% of that determination volume of the surface water supply is available in a year, then the applicant, and typically the application would come from the water provider, can pump groundwater to backfill or firm that supply up to 80% of the determination volume. That application must be submitted on an annual basis, and that should be submitted concurrently with the applicant's annual report. It's important to file it with the annual report because that's when we know how much water of each type was used, and that's when we'll be able to best assess the applicability and volume of the drought volume exemption for a particular year. So the rule clearly defines the amount of the drought volume exemption. However, there are a few other aspects of implementation that have not been clearly defined in the rule. And in particular, one question that we have received in the past frequently is, what happens if the surface water supply in question is among multiple supplies included in the determination of assured water supply? This is particularly an issue for designated providers who may have multiple supplies, multiple surface water supplies, as well as groundwater, effluent, and et cetera. The draft policy statement provides additional guidance in this respect. It's important to note that as a policy statement, it does not constitute a final determination regarding any application. We would determine those on a case-by-case basis. We do recognize that circumstances will differ for any applicant, and particularly in times of shortages. And so extenuating circumstances may require alternative approaches. So the intent of the policy statement here is to provide guidance in order to allow water providers and water users to plan and understand how the drought volume exemption will be implemented. But we do understand that there could be special cases that may vary from the way we're describing our guidance in this policy statement. So next, please. In the case of a determination of assured water supply that includes multiple water supplies, the applicant should maximize the use of other water supplies, including a proportionate volume of any applicable groundwater allowance, prior to applying for a drought volume exemption. Pursuant to ARS section 45-576, which provides the definition of an assured water supply, in subsection L2, the groundwater use within an AMA that is subject to assured water supply determinations must be consistent with the management goal of that AMA. And the drought volume exemption in the rule is intended to be a very limited exemption from that general requirement. So we think that this guidance is very consistent with that statutory requirement. Next. This is also consistent with Arizona's public policy as set forth in the Groundwater Management Act, in which the legislature declared that it is the public policy of the state that in the interest of protecting and stabilizing the general economy and welfare of the state and its citizens, it is necessary to conserve, protect, and allocate the use of groundwater resources of the state, and to provide a framework for the comprehensive management and regulation of the withdrawal, transportation, use, conservation, and conveyance of rights to use groundwater in this state. Reductions in Colorado River supplies may increase significantly, both in volume and frequency, and we know that that may lead to reductions in CAP water availability for delivery earlier and in greater volumes than previously anticipated. So essentially, we're expecting shortages of CAP water to be much larger, more frequent, and to hit earlier and hit at higher priority levels than we previously thought. This policy statement is intended to offer guidance to allow municipal providers to adapt to those changing conditions. So our policy statement sets out upfront that the applicant should be implementing a late-stage drought response plan prior to seeking a drought volume exemption. And this is something that we think is probably just common sense and a matter of reality. The drought volume exemption only allows you to firm up to 80% of the supply that was determined to be physically available. So when you've already lost 1/5 of your supply before you can even implement the exemption, it seems that it should go without saying, but we're saying it anyway, that you should be in the subsequent stages of your drought response plan prior to reaching that point. And so we anticipate that applicants will be implementing their drought plans well in advance of that threshold and should be implementing multiple components of that late stage of their drought response plan. So when we talk about a drought response plan and implementing the multiple components of a late stage, essentially we're saying that there should be measures and implementation that go beyond general public awareness and education campaigns. In particular, we're giving you some examples. It's not a limited list. This is just an example of ideas of what we're thinking we would expect to see. So comprehensive distribution system water loss control, including annual audits and system improvements, limiting non-essential water use for public buildings and public areas, restrictions on non-essential water use throughout a service area generally, implementation of measures to significantly reduce residential and commercial, institutional, and industrial water use. In other words, all water use. And one example would be ordinances to restrict non-functional turf buyback programs, water budgets, retrofit programs and requirements, or an enhanced rate structure to further disincentivize water use. So that's a list of examples. It's not intended to be the comprehensive list. We're not using that as a checklist necessarily, but that's to give you an idea of what we expect to see implemented prior to receiving a request for a drought volume exemption. Additionally, the rule provides that groundwater allowances must be utilized before seeking a drought volume exemption. So the rule language specifically references other than the groundwater that is accounted for under subsection A, C, or E of this section. And those subsections reference the groundwater allowances. We know that in some of the AMAs, the groundwater allowance may be calculated as a lump sum for the 100-year period rather than an annual volume. We would then anticipate that the applicant apply the average annual volume of the groundwater allowance. So you are not expected to use the entire lump sum of the groundwater allowance each year prior to ever requesting a drought volume exemption. We're essentially expecting that an applicant will use 1/100th in a year. The applicant should maximize the use of all other supplies available to them prior to requesting a drought volume exemption unless an insurmountable barrier precludes the use of a particular supply. And when we talk about all other supplies available to them, we'll be looking at this from the perspective of what is included in the applicant's determination of assured water supply. We recognize that there may be supplies that are not included in that determination, and they may not be included for a particular reason because the applicant did not anticipate that they would be available to satisfy demands on a 100-year basis. While we would certainly encourage applicants to use those other supplies that may be available, even if they're not a quote unquote assured water supply component, we will be expecting every applicant to utilize any volume of water that was included in the assured water supply determination prior to requesting the drought volume exemption. This would include groundwater to be withdrawn outside an AMA and transported to the AMA for the applicant's use, and effluent for direct or indirect potable reuse. We expect that those supplies should be put to beneficial use prior to requesting a drought volume exemption for groundwater use. We also recognize that certain determinations of assured water supply acknowledge specific limitations to use, and that can be the restriction of entitlement water to be used only on eligible lands. That could also include the direct use of effluent only to serve non-potable demands. So when those certain limitations are explicitly recognized in the determination of assured water supply, we will certainly also recognize those when we're considering an application for a drought volume exemption. We're not going to ask you to do anything that we obviously recognized would not be done when we issued the determination. Then next slide, we'll talk about insurmountable barriers. And this is essentially an exception that we expect to be limited and applied on a case-by-case basis. And we do recognize that there will be cases where a surface water supply shortage may occur earlier or in substantially larger volumes than previously anticipated. As we mentioned earlier, that's particularly likely to be the case with CAP water. And so that may mean that those supplies are reduced earlier than those alternative water supplies in the determination, or additional infrastructure may be available to help accommodate reductions in the reduced supply. So the department will consider on a case-by-case basis granting a drought volume exemption to a designated provider under the following conditions. In those cases, the applicant must provide a very compelling justification for the inability to fully put the alternative supply to beneficial use. So it's not just, we're not ready. We need a very compelling reason why we're not ready. We need to know exactly what the barrier is. And additionally, the applicant must provide and implement a plan to fully put the supply to beneficial use within a reasonable time frame. We're anticipating that a reasonable time frame will be within 3 to 5 years. So if there's additional infrastructure that needs to be constructed, we understand that if the shortage has come earlier or in a greater volume than anticipated, then it may take additional time to fully construct the infrastructure. We would like to see your plan for completing that infrastructure construction and getting the infrastructure into operation in order to utilize that alternative supply. So if those two conditions are met and the director approves the drought volume exemption, then that drought volume exemption would still be subject to a new application in each subsequent year. And again, we would expect that application to be filed concurrently with the applicant's annual report. And in those subsequent applications, the applicant will be expected to update both the justification and the timeframe and the plan to put the supply to beneficial use, including a description of progress achieved in the interim for each year that an application is submitted. And if we see that a particular applicant has not made reasonable progress in putting that supply to use, then we may need to review the designation subject to 711C to determine whether that alternative supply should continue to be included in the determination. And again, we think that it's perfectly reasonable that if that alternative supply cannot be put to beneficial use within a 3 to 5 year time frame, and according to the plan that the provider has proposed to the department, then it does certainly raise the question of whether that supply is an appropriate assured water supply component. Additionally, the use of the drought volume exemption for a surface water supply needs to be based on historical use. So if an applicant has historically not used the full determination volume of the surface water supply for whatever reason, that may be because the supply, because they haven't grown into that supply in particular, then the drought volume exemption should not be used to relieve the applicant from replenishment requirements or other costs that it would have faced regardless of shortage. So we have an example on the following slide. Oh, and I should clarify that we'll be determining historical use based on the average of the highest 3 years of the last 5 years. So if an applicant has a determination of assured water supply that includes 1,000 acre feet per year of groundwater and 500 acre feet per year of CAP water, and typically the applicant uses 1,000 acre feet per year of groundwater, but only 300 acre feet per year of CAP water, then due to shortage reductions, the applicant is able to order only 250 acre feet per year of CAP water. Again, this is obviously a drastic scenario. We're not suggesting that your CAP water will be cut by that volume in any particular year. Then the applicant is only eligible for a drought volume exemption of 50 acre feet per year to replace their historical average use of CAP water. If we were to implement it otherwise without it taking into account that historical use, then it would have been 150 acre feet per year, which is based on the 80% of the determination volume. And so that would end up exempting the pumping of groundwater that would typically have been subject to replenishment in any other year. So the fact that there is a shortage is not a boon or a windfall to pump groundwater that you otherwise would have been pumping and replenishing. Additionally, if a provider or a water user is accruing long-term storage credits in the same year that they have requested a drought volume exemption, we do not think that they are eligible for a drought volume exemption. Effectively, if you have water to store during a year, then you probably do not need to be pumping groundwater in order to make up for a shortage reduction to your supply. So this does not affect the ability of an applicant to rely on annual storage and recovery, obviously, because then you are not left with additional long-term storage credits that you're accruing from year to year. This only applies to the accrual of long-term storage credits. And we believe that this is consistent with the statutory framework. The legislature established the underground storage program to protect the general economy and welfare of this state by encouraging the use of renewable water supplies, particularly Colorado River water, instead of groundwater, and permitting an exemption for groundwater use during shortages, while the groundwater user is actually accruing long-term storage credits, would conflict with the policies and laws regarding underground storage and with the purpose and policies of the Groundwater Management Act and the Assured Water Supply Program. Additionally, in some cases, an applicant has pledged an alternative supply as a backup supply. And that alternative supply may be a different renewable source of water. It may be a particular source of groundwater withdrawn outside an AMA to be transported into the AMA, or it could be the use of long-term storage credits accrued from that same shortage-prone supply in normal years. And pursuant to, and so I've cited the rule provisions that provide for that backup supply. And under those rules, we would then calculate that a greater volume of the shortage supply is available for use under the assured water supply determination based on the use of that backup supply. Because that the determination volume was expressly reliant on that backup supply, we do expect the applicant to use that backup supply in the event of shortage rather than turning to a drought volume exemption. We also know that voluntary system conservation has been a very significant program on the Colorado River in recent years in particular. And so we don't think that we can make a determination up front about whether a drought volume exemption would be available to an applicant who has participated in a voluntary system conservation program. We think that each applicant or each prospective applicant, I should say, because you're typically considering participation in a system conservation program prior to that year or during the year, and then you'd be applying for the drought volume exemption after the fact. If you're thinking that you would like to participate in a voluntary system conservation program, but you may end up needing to request a drought volume exemption for the pumping of groundwater in the same year, then we anticipate that we recommend that you consult with the director and the department prior to participating in that voluntary system conservation program. We think that this is a very case-by-case question, and we'll have to weigh the risks and benefits, both related to mining the groundwater supply without replenishment and protecting the Colorado River system to determine whether a drought volume exemption should be available under those circumstances at that particular time. It's going to be a very case-specific analysis. We would need to include the current and projected reservoir elevations on the Colorado River system, for example, current and projected hydrology, decisions, determinations, or other guidance by the Secretary of the Interior, and the status of Colorado River negotiations, as well as local groundwater supplies. So even the groundwater availability in the area where a particular water user is located could factor into that determination. And of course, we know that we're in a time of great uncertainty, so we obviously can't identify all of the factors that could affect that decision in the future. So I have walked through the major components of the policy statement, and we have allotted some time for questions from the audience, both in person and online. For those of you attending in person, the huge crowd that we have here, raise your hand if you have a question. And for those of you who are joining us online, please submit an online speaker card, and there should be a link posted in the chat box. While we're waiting to see if we have questions, I want to point out that we would like your public comments on the draft. Please submit those to Sharon Scantlebury by December 7th, 2022. And details on the policy statement, as well as contact information for Sharon, are available on our website. We've included a QR code so that you can use that in order to access our website. We also have the website linked in the presentation. That's available at our website with a /laws, rules, policies with hyphens in between each of those words. At this time, are there any questions from those of you attending in person? Okay. We'll let you use the mic.
Well, thank you for that presentation. It's really helpful to anchor us as we review the policy and understand the department's thought process on this. I'm just curious, in the past, when the department has implemented the drought volume exemption, I think maybe 2002 might have been a year, or at least it was requested for that year when there were surface water allocation shortages. Has it been implemented in the past? And if so, is this different than those times?
My understanding is that we have received one request in the past, and I apologize, I should have checked my notes on this prior to the meeting. I do not know what action the department took at that time. We believe that we have more information about shortages we don't have as much information as we would like about shortages in the near future, but we have a lot more information about the way that the Assured Water Supply Program works now, and the way that that multiple water supplies can be implemented in a way that allows us to have better policy guidance on this question.
So this is Carol Ward. I can answer that. There was a request for a drought volume exemption, but it was withdrawn by the person that asked, the city that asked at the time. So it didn't actually become something that the department implemented at that time. So we didn't have, I don't think we fully fleshed out a strategy at that point. So this is our first time doing this, really.
Circa 2002, right? I think called. Yeah.
All right, and our water bank manager, Virginia O'Connell, has a comment that she'd like to contribute.
Go to the podium.
Okay, so it's still, okay. So I have more of a comment than a question. At the Water Bank's last meeting in September, we also discussed, distribution of long-term storage credits to help mitigate shortage reductions. And some of these issues came up there as well, whether the bank has the authority to try to prolong the use of its credits and maybe put in some conservation requirements or some of these similar decisions. And you mentioned that you would be submitting a form with the annual report. I imagine that form would include some questions on whether a designated provider or provider did some of those things, before getting a DVE. So depending on what happens at our meeting next week and decisions made there could be some overlap with the bank too. On the annual report, those forms come after the year, but the water bank makes its decisions on firming prior to that year. So I just wanted to raise that, we may have some overlap and need to have some of that information or look at the forms that the department anticipates providing, for that year.
Thank you, Virginia, and that's a good point. Of course, we will make every effort to accommodate that overlap and make sure that our policies and the overlap in our policies is clear with respect to implementation for any applicants. And Virginia also raised a good point. While we are anticipating that providers or water users should submit their application with their annual report, we will be working to develop a form that can be submitted with the annual report to request that exemption. We will also be coordinating with the CAGRD in order to ensure that we are able to address, in order to ensure that we're able to provide a determination on the drought volume exemption in time for the CAGRD to carry through their obligations and without disrupting the CAGRD's process. So we will be working on that going forward. Are there any questions online?
Jenna Norris has asked to speak, so I have unmuted her.
Okay, thank you. Jenna?
Hi, everybody. Can you hear me?
Yes, we can hear you very well.
Okay, excellent. I have just a simple question of how, and maybe you haven't thought about this yet, but and that's okay too, but my question is just how would this overlap potentially with the redesignation process coming up, and how would an application for this fit into that? Of course, we have our current designations that are for the larger municipalities such as City of Peoria, which I should have introduced myself, Jenna Norris, City of Peoria. But how would this maybe dovetail into the upcoming redesignations that a lot of us will be going through?
So I don't think that from the department's perspective, it necessarily changes the way that the department will consider applications for assured water supply determinations. We will still continue to review applications and issue determinations according to our existing rules and policies. I think that this policy really has more to do with how the drought volume exemption is implemented. I, I think that there are some realities that, there may be certain supplies that we know are not going to be available in the same volumes that we previously thought. In particular, the NIA priority CAP water. And so that will be implemented just through our normal rules and policies and practices that we've used in the past. I think this policy really just affects the implementation after the determination is issued. I'm certainly willing to entertain any questions and would love to hear comments if someone can identify a specific concern that might affect that we have not anticipated. Are there any other, okay, I'll give everyone just one more minute to submit an online form. Or if you're having trouble finding the online form, if you want to raise your hand. All right. And again, we certainly would like input from the public regarding the draft policy itself, as well as information about how to submit comments on the policy will be available at the website that's listed on the screen. We also have a handy QR code if that's an easier way for you to access the website. And we would like all of our comments submitted to Sharon by December 7th, 2022. Would you like to go to the next slide, Sharon? Thank you. And the draft policy statement, I mentioned that it would be at our website. We do anticipate adopting a substantive policy statement by the end of the year. When we adopt it, it will take effect on the date signed by the director. And the final substantive policy statement will be posted on our website with our other substantive policy statements. And we've given a link to that. This would be under the assured water supply category on that page. And of course, we will file the substantive policy statement with the Secretary of State and publish notice in the Arizona Administrative Register pursuant to ARS Section 41-1013B. So it will be available to the public. Again, the draft is available on the website listed at the top of the screen or accessible through the QR code. Are there any other public questions or comments online?
Nicole, can you hear me?
Yes, I can hear you.
Sorry, this is Doug Dunham with EPCOR. Our firewall doesn't play well with your link, so I have to call in. So just real quick, a comment on the wish the department would take into consideration when you're reviewing specific applications for the drought exemptions on the conservation piece. For private utilities, we are somewhat restricted versus a public utility on the ability to implement ordinances and other use restrictions. We do have some authority limited from the commission, but we don't have the ability to change zoning or to change use patterns or that cities enjoy. So just would like to make sure that the department keeps that in mind during those review processes. The question I have is, in looking at the policy statement and the rule, the drought exemption appears to be only available to volumes that are actually approved under an assured water supply. For example, most of my West Valley systems have relied on certificates of assured water supply, not designation. And those have been primarily issued as groundwater based. We have been fully utilizing our CAP allocations to offset the groundwater use as much as possible. But because that cap allocation was not included in the original certificate determination, it appears that the drought exemption would not be available to those citizens, those water users. Would you agree with that conclusion?
Yes, I think that I would agree with that conclusion. I'm obviously speaking just directly in response to your question without having internal discussion, but I think it does seem that it's consistent with the rule that the drought volume exemption is only applicable to a surface water supply that is included in the determination of assured water supply.
Thank you.
And we would, of course, take into account the considerations that you mentioned regarding the drought response plan. And so we anticipate that private water companies would also still have a drought response plan that would incorporate components at different stages that are consistent with the Arizona Corporation Commission's requirements. And so while we recognize that there may be fewer options and, certainly even beyond the Arizona Corporation Commission, we recognize that private water companies are not authorized to implement zoning restrictions or things like that. So we would expect any provider to have a drought response plan that they can implement within the scope of their existing authorities and to be implementing the components that they've identified in that plan.
Understood. Thank you.
Next, we have Brett Fleck from the city of Peoria.
All right. Brett, go ahead.
Yeah, thank you. Yeah, Brett Fleck from the city of Peoria. First, I want to take a moment to thank ADWR staff for taking the initiative to flesh out this approach to groundwater management. It's really important that we identify these sorts of uses before we need them potentially in the near future. So kudos to you all. I'm following up to a question that my colleague Jenna Norris asked a few minutes ago with a potential use case. And while I wasn't there during the previous designation time period, I am looking at our own designation, and I see supplemental groundwater used to essentially firm surface water supplies. And my understanding is that supplemental groundwater has an interplay with physical availability of groundwater. I'm not 100% sure if that supplemental groundwater was based on a drought pumping exemption assumption, but to the extent that it would be, my ask of DWR is that we think about that potential overlap. I'm just suggesting that I don't have a particular answer or question at this point, just bringing that up.
Okay, thank you for pointing that out. We will, I recall the volumes that you're talking about, and I think we will take a closer look at that to clarify how this policy would be implemented with respect to that volume.
Thank you. I appreciate your time.
Okay. Are there any other comments or questions at this time? Okay, we would again encourage you to please submit comments and or questions. And again, no later than December 7th. And we've posted the address here on the screen. Again, the QR code, the screen, the website. Sorry about that. And with that, I think that we are ready to wrap up today unless anyone else has anything. Oh, just a minute. Oh. We also wanted to clarify that this presentation will be posted at the website that you see on the screen. So you will be able to access this presentation as well as the draft policy statement. Oh, just a minute. We have more information on the drought volume exemption request from 2002.
So to answer the question about the drought volume exemption being granted previously, my mistake, Town of Gilbert was approved for a drought volume exemption back in 2002. The one I was thinking of was in 2012, and that one was retracted. So it was implemented before, but I don't have any details on that. I can follow up more for you, Patrick, later.
Thank you, Carol. All right, I think with that, we have completed our presentation, and if you have comments or questions, again, please send them to Sharon at the address, email, or fax number shown on the screen, or accessible through the QR code. Thank you.